Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. First of all, I'd like to wish you a happy new year, 2025. I hope you had a great holiday. I had a fantastic holiday myself. My son Michael got married over the weekend with a wonderful woman named Caroline. I wish him both a lifetime of happiness and love, and I'm excited for what is yet to come from them. So it's such a special day here. I have a live studio audience. I have my friend Steve Roos here with me, as well as my beautiful wife, Sharon. So we have two of us here, and then three of us that are listening to the podcast, which makes five. Of course, Sharon is rolling her eyes, thinking I should not leave my day job, and she's probably right. So today's episode 82 of Business SOS, as we keep moving forward to episode 100. We're getting there. I remember when I did my first episode thinking 100 seems to be far away, and I'm getting closer to that, and we're going to do a special event for the 100 episode. Today's topic, I want to talk to you about mediation. And I've mentioned mediation in the past as part of different segments. I don't recall that I dedicated a specific episode of mediation, but I want to talk to you about that as well. And why mediation is a cost-effective method or tool for resolving legal disputes. And before I start, I would like to ask you something. If you have listened to the show for a while, first time, if you like it, please follow us, and also give us a 5-star review. I'd like to ask you that. That helps the algorithms recommend the show to other listeners. As well, if you're watching it through a YouTube channel, subscribe and give us a review as well. Comment. Let us know what you think. I review those periodically as well, and I respond to them. So what is mediation? Mediation is an alternative dispute resolution. It's the way I can describe it to you, it is a meeting where the objective is to find a solution. It is done through a mediator, and a mediator that is trained, and I'll go over the training in a few minutes, that is a third-party neutral that has nothing to do with the case. And that person's role is to find a way to have a compromise between the parties and resolve the legal dispute at that afternoon or that morning, and try to avoid the case from going forward as to the litigation process. The mediation is confidential. There's some benefits to mediation, and I'm going to go more specifically into those, but briefly, it's an informal process that you're going to have more of a conversation. It is done sometimes face-to-face in an attorney's office or a mediation service office, or it can be done via Zoom, like many of them now we're doing via Zoom. And in fact, I think I haven't done a in-person mediation in a while. I think the ones that I've done the last 5 years have been via Zoom exclusively, and they're very effective as well. The mediators. Who are the mediators? Well, the mediators can be an attorney or can be a retired judge. You don't have to be an attorney to be a mediator. There's a course that we take to become a Florida Supreme Court certified mediator. And that's a 40-hour course that people take, and then you have some supervised observations. When I took my course, there were 7 supervised observations to see other mediators observe, and then you become certified. Then you continue getting education throughout the process with experience. Why is mediation so effective? Mediation is effective because, in my experience, when you have a legal dispute, you're entrenched in the process of litigating. Somebody files a lawsuit, and when my clients tell me, half of the stuff, most of the stuff is lies, they're really lying, and they get really offended by the lawsuit. And when somebody's going to sue you, they're not going to say nice things about you. So you have to take a step back. And I tell my clients, listen, the attorney's the one that drafted this complaint. So don't take it personal. I know you will take it personal, but you have to take a step back and understand where it comes from. And so people want to fight, and then you have the answer to the complaint, and you have to answer questions to discovery. And you as the client, you don't feel that you have a lot of control through the litigation process. because the attorneys have the control for the most part. We decide, what questions, how to answer the questions, even though we get information from you, what documents are going to be answered, provided. We decide, what motions to file, what motions, how to respond to each motion, what to say at the hearings. As a client, when you're involved in litigation, you don't have a lot of control. As opposed to a mediation, you have control. And that's one of the key benefits of mediation, client control. There are 8 of them that I will discuss here shortly, but you have client control. And what I tell my clients is that when the parties begin to focus, to spend 4 hours. In some cases, their mediations take longer, but an average 4 to 6 hours is an average time for mediation. When the parties begin to focus on thinking of a solution, thinking of how to get this matter resolved, your mindset changes. The mindset changes from let's litigate, let's continue, take this case to trial, let's go ahead and take depositions of all these witnesses that will testify for me, to how I can resolve this today, and let's be frank about it, stop paying legal fees. That's one of the motivating factors in trying to get the matter resolved, that you don't want to continue the financial bleeding that goes with a litigation process. And a mediation gives you that opportunity to at the very least have the conversation. And an example I can give you, I deal with a lot of partnership disputes. It's a business divorce. Partners, something happens, one person accuses the other of stealing money from the company or using the company credit card for vacations, not doing the job, and there are just many others. And for the most part, mediation is when they have had really the most in-depth conversations and the more in-depth time to try to resolve it. And I see more of a lack of communication when I see a lot of partnership disputes and a lack of guidelines and what roles and responsibilities each partner has. And many times I see there's no operating agreement, and we have talked about that before, that if you're going to have a partnership, my recommendation is to have a partnership agreement or an operating agreement or bylaws that each of you know what you're supposed to do and what limits you have in terms of limits of authority to run the company. An example, you want to buy, some paper for the copier, you really don't need to check with your partner. That's something very routine. But if you want to go ahead into a 5-year lease for a new location, that's something your partner should know, because that has some consequences to the business and to you financially. So I'm just giving you those kind of extreme examples just to make the point. So when the partners go into this mediation process, the mediator's role is to keep the parties in the mediation process until there's a settlement or there's an impasse. And there are 2 possible outcomes here that you will have. If there's a settlement, then the parties go draft a settlement agreement, and then the settlement agreement becomes the document that will govern the future relationship, whether it's a payment arrangement, whether it's a transfer of assets, whether it's a transfer of shares. The lawsuit pretty much ends, and the settlement agreement becomes a new document that you go forward with. And then the attorneys will file the proper paperwork to dismiss the lawsuit and to end the case. The other option, the other outcome that could have in a mediation is that you have an impasse. That means is that the parties negotiated and they just decided they're not going to settle, and they rather have the matter be resolved by the court system, whether it's a bench trial, which will be a trial handled by the judge, or a trial by jury. With the jury, you select the jury, and then the jury will render the judgment. So there are 2 possible outcomes. Now, The mediations are confidential, meaning that whatever is stated at mediation stays at mediation. No one can be asked to testify about any admissions they have made at mediation. And in fact, attorneys can be sanctioned if they ask questions regarding anything that happened in mediation. The mediators cannot be asked to testify anything regarding the mediation process. There are some exceptions when the mediator might be asked to testify, but we don't have to go into those right now. That's really more of a nuance. And the mediator cannot disclose anything that happened at the mediation, neither the attorneys, neither the parties. And there's some exceptions, threats, any, crimes. Again, it's not something that we need to discuss at this point, but for the most part, just remember that the mediations are confidential, and it is designed to be that way to really give the parties freedom to talk and discuss and to find a way to solve the problem. If people are afraid to say something to the mediator, even if it's an admission, then the parties are not going to be open to discussing their issues or their concerns. Again, when I said earlier the mediator is supposed to keep you in the mediation until it's a settlement or impasse, you're not forced to stay at a mediation. You can decide at any moment, say, you know what, I'm not going to negotiate anymore, I'm done. So the mediation, although it is, some of them are required by the court to attend, you're not required to settle. And that's where it goes into your control. If there's an agreement, it's because both parties agreed that there will be a settlement. If there's no agreement, it's because obviously it's obvious that both parties decided that they are not have the meeting of the minds, and there's no need to move forward. But no one is required to settle in mediation. What the mediators do, they say they're required 2-hour minimum, but it's really for their pay in some cases. Sometimes require 4-hour minimum guaranteed. So if you stay there for half an hour, they're going to get paid for the 4 hours or 2 hours, whatever the contract states. When we go to a mediation, I tell my clients, go with an open mind and really trust the process and allow the mediator to do his or her job. And one of the keys to mediation is preparation. And I enjoy mediation, and the reason I like mediation is because it gives you the opportunity to really look at it as a wide canvas. You can, especially in business disputes, you can be very creative in how you approach a business problem and how to resolve it. So that's what I enjoy it. And also, from my perspective, it gives me an opportunity, the only opportunity that I have to really address the opposing party. Attorneys are not supposed to talk to the opposing party unless the other counsel agrees to or they're unrepresented. But if they're represented, I can only talk to the attorney. And of course, I will be addressing the other party when I'm taking a deposition, but that's a more structured process of asking questions and answering. The attorney objects. So it's really, I can have a conversation with the opposing party, and that's also under oath and is recorded, it's transcribed. So it's a different process, but in the case of a mediation, I have the opportunity to really explain to the other party my position on behalf of my client, but also to them to get to know me as the attorney who is going to try to suing them, or the attorneys who are defending my client that they're suing. And that is important because that will be the first time that they get to know me. And clearly, the objective is to let them know, listen, whatever you're doing, you have somebody prepared on this side. There are no guarantees what the outcome will be on anyone. But it gives me the opportunity from our perspective to really show why we believe that will prevail in the litigation and explain it in our terms. And my role is to educate the party and the attorney on our position, and that's the only opportunity that I will have. The other party doesn't have to answer any questions. I'm not asking any questions. but it gives me the opportunity to tell the other side, this is why we believe we're right. This is what will show us the evidence. This is what I will believe that the court will do if we prevail. And I will not have that opportunity because before that particular event in which I can talk to the client, the other side, the only information that party has received has been only from the attorney based on his or her perspective, but never heard from me. So that's why I love mediation, because it gives me that opportunity to really show them what is at stake and what we're willing to do, what we're prepared to do for this case. Likewise, this is also an opportunity for my client to get to know the other side, get to hear from opposing counsel, get to hear their perspective about their position and why they believe they'll prevail on the case. We're not going to agree. We're not going to, that's the reason we're in litigation. But it is important in a mediation to listen. And I tell my clients, the most important thing you can do is to listen. We have to understand their perspective in order for us to be able to arrive or potentially arrive at a settlement and find out where areas that we can agree on, and then figure out the areas that we disagree and let the mediator do his or her job and trust the process. The mediators have a dual role. I don't know if it's a dual role, but they have a role of confidentiality. And let me explain what I mean about that. So when you start a mediation, you start everybody together. And could be in a Zoom conference, like all of us know by now. We're in a conference room. The mediator will explain the rules of mediation, his role, her role as a mediator, and the rules of confidentiality, courtesy, and the objective is to see if there's any possibility of arriving at a settlement and kicking around ideas to get the matter resolved. After each party provides their opening statements, usually the plaintiff will go first. It's simply more of an introduction about the case and addresses the other party and whatever you want to say, and vice versa. The mediator then will separate the parties in separate caucuses, as we call them, or now virtual rooms. So in my case, I'll go with my client in a virtual room, and then the other party goes in the virtual room. Then the mediator will go to each side and begin to speak privately with each side. And that information, that conversation is confidential. Well, the mediator knows what happened and what takes place. Now, it's very common for the mediator to, before they leave the virtual room or the room, say, is there anything that we discuss that you would not like me to share with the other side? And that goes more into strategy and tactics. So it is important that your attorney understands that the process of mediation, but also the art of negotiation. That's very, very important, because it is a negotiation through a mediator, and you're negotiating. So then mediator goes to the other side and begins to, and talks to them, and maybe offers are fielded. He brings an offer, and we begin that process of negotiation. And it could take, sometimes takes 2 hours. Had a mediation recently that took 8 hours. It got resolved, but it took longer than usually expected. And I have my own unique rules for mediation. We're not going to go into that right now. But just to kind of give you an idea, that's usually the way it works. You get together first, you separate into caucuses, you talk to the mediator, you get to speak with your attorney, you spend basically a few hours with your attorney. So there's plenty of time to talk to your attorney throughout the mediation process. And then see what the process goes. The one thing that I tell my clients in the mediation is that when the mediator comes in with some type of offer, and just listen to it, and just we'll ask the mediator to leave the room for a few minutes so we can speak about it. And then we can get the mediator come back in and decide how to proceed, whether accept, reject, or counteroffer. There's only 3 options here. Or get more information, which is the 4th option as well. But it's important that you and your attorney are on the same page and how you're going to manage that mediation. And it's important to also, when you disclose something to the mediator, it's something you want to disclose. The mediator is also gathering information from you and from the other side. The mediator is trying to figure out a way to make this happen. That is his job or her job. So it's important to understand what information is shared and when. Prior to the mediation, I should have said this before, the attorneys usually send a mediation summary to the mediator, a confidential mediation summary. Could be 1-2 pages along with some pleadings, just to give the mediator familiarity with the case. So that way, when they come in, they're prepared and they can move forward. So I went ahead and I have the 8 C's of mediation, and actually in my book, Business SOS, They Common Legal Mistakes Business Owners Make and How to Avoid Them. In pages 132 to 134, I go through the 8 C's of mediation, and they're not mine. And I said that in the book. It's actually, I had a mediation a few years ago with a magistrate and in a federal court case, and he talked about these. So I wrote them down. I forgot his name, so I want to give him credit. But I liked them, so I went ahead and kind of wrote them down, and then I kind of incorporated some of these in my book. And I'll go with some of them. I mentioned client control, that you have as a client control of the process. And I make that very clear to my clients. This is your opportunity to get this case settled. If it settles because you worked it out, we were here to advise you, and the other party agreed to it. There's also cost control. And I'll just give you what a typical mediation would cost. Just to give you an example, the average mediator ranges between $400 to $600 an hour. I've seen higher, but I think that's a little bit too much in my opinion. So the fees are usually divided by both parties. And the attorneys, are responsible for those fees. So you have to pay your attorney in advance to cover those fees. So you're looking at a, say, 6-hour mediation, say $500 an hour, $3,000 divided by 2 is $1,500 each party. That's just give you a typical example of what a mediation will cost if you're in a mediation. And it varies from case to case, but that's kind of an average for my opinion. Now, when you compare $1,500 per year plus your attorney's fees on 4 hours or 6 hours trying to resolve the matter versus the cost of spending, the next 12 months litigating the case with a high degree of uncertainty because there are no guarantees what's going to happen at the end, the mediation cost is worth the investment because you have an opportunity to focus on those particular hours and getting the matter resolved. Comfort. The mediation is in a comfortable place. You can be in a Zoom at your office or your home. You can take breaks. So you're really more in a comfortable setting, and it's more relaxed. If it's in a mediator's office, they usually have soft drinks, they have snacks. It's a more comfortable setting to be in a mediation than having a deposition taken, for example, where you have to answer questions under oath with a co-reporter, and you have opposing counsel just hammering you with questions and trying to get you to admit things you do not want to admit. Commitment. The mediators often aim to keep the parties in dispute in the mediation process until the dispute is settled or at an impasse. Mentioned that before. The objective is to negotiate in good faith, trust the process. There might be offers that you might feel that they're insulting. That happens in most mediations. But by allowing the process to continue, there's an opportunity. No guarantees, but it's an opportunity. Courtesy. Again, the objective here is to be in a courteous process, no name calling. And I'll tell my clients, you will hear things you do not like. Just keep your poker face. Do not react to them. Just let them go. We're going to separate soon. Okay? As I notice a lot of animosity with lawsuits, and that's understandable. I mentioned creativity, and creativity is really a key portion of this, that you can be very creative in developing a solution to a legal problem, especially a business problem. There are many different options that we have to come up with a solution. Confidentiality, process is confidential. What happens in mediation stays in mediation. Compromise. The objective of the mediation is to see if you can arrive at a compromise. And this is very important. And a good settlement is when everybody leaves a little bit unhappy. That is a fact. If you are being sued for money, if you settle, very likely you're going to pay a little bit more than you would agree to pay. And if you're the one who's receiving that settlement, very likely you will be receiving less than you really wanted to receive in the first place. But that's the nature of compromise. You make a calculated decision. Is it worth it for me to be in this litigation and continue the uncertainty of it? Or perhaps it is good for me to end this today, put closure to it, which is another cease, closure, and move on with my life. Reality is you're not in the business of being in litigation. That's what we do for a living. But as a party to litigation, that's extremely stressful and financially draining. So having a mediation process, a mediation, give you the opportunity to resolve it. It gives you the opportunity to put closure to that chapter and move on. And every time that when we settle a case, there's a sense of relief, not only from my clients, but also from the other side, that this nightmare is over. And so that's why I'm a big proponent of it, because it gives the parties an opportunity to get it done effectively, confidentially, and just move on. And that's what we want to do. Just get this chapter done, move on, get this case closed. Another point that I wanted to make, a question that people might have, well, will I have more success in mediation than in court? The answer is it depends. But I will tell you that mediation is highly effective, has a high success rate. In my experience, I've been doing this for 20 years. I'm sure I've done a few thousand mediations by now. 95% of these cases settle on mediation or through attorney negotiation, especially in a business litigation context. Because at some point, the parties in the litigation will ask the question, how much money am I going to continue spending in this case? Is it worth it? And that's a question anybody in a lawsuit should be asking. And if you have the opportunity to resolve it at that point, you're done. So you have a high success rate with mediation. It is cost effective. It stops the financial drain, as I mentioned before, and you get closure as well. The type of cases that go into mediation, very briefly before we run out of time, partnership disputes, we do quite a bit of those that go into mediation process, a breach of contract claims, real estate disputes, employment matters, divorce and family law, negligence cases, and many others. If you're in a lawsuit in Florida where there is, small claims, you automatically go to mediation. We don't handle small claim cases. But county court and circuit court, even federal court, you will be required to attend mediation. And it's usually they ask you to go to mediation 60 days before what we call calendar call or the pretrial conference. And that's pretty much after you spent nearly a year worth of legal fees. And they say, can you settle the case before you go to trial? I like to do mediations a little bit earlier than that. Maybe not right at the beginning of the case, but maybe after some discovery has been completed. Let's just get a mediation conference in to see if at this particular point this matter can get resolved since we have a little more information about the case that we had before, about each party. Simply because what I mentioned before, the opportunity to settle is right there. If you go at the end, it is fine. That's required by the court. But oftentimes, the parties have invested so much in the lawsuit, all the deposition they have taken, all the motion practice, all the attorney's fees, and they're so invested that often I have clients saying, I just take my chances. If I would have, done this before, maybe, but now, might as well see what happens. And that's a missed opportunity. So I'm a big proponent of having mediation a little bit earlier, simply because give you an opportunity to get out of the case faster and solve the legal problem. Practical tips for successful mediation before I close. Be prepared. Preparation is key to any successful mediation. In fact, my practice is before I have a mediation conference, I do meet with my clients and do a mediation prep. We talked about the case. We talk about strategy, tactics, ranges of potential settlement options. So we're prepared. Maintain an open mind and listen. It's important for us to listen to the other side to understand where they're coming from. Choosing the right mediator. I like mediators that are prepared. I work with anyone. I don't have a specific that I have to work with this type of mediator. No, as long as they're prepared and they read the material beforehand and they have a good track record, I work with anyone. Focus on the big picture. It's important to understand what you're trying to accomplish and understand that the goal is to get this lawsuit ended, finished. And if you arrive at a settlement agreement, make sure that the terms that you agreed upon are included within the settlement agreement. And that's probably the most important part, that no item is missed. So this is a good for today. Hope you enjoyed this, this primer on mediation, a crash course. And if you have any questions or comments that you'd like to send me, you can send me an email at richsierra.com. My website is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. If you'd like to watch the video of this podcast, we're at YouTube at youtube.com/@RichardSierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. If you'd like to give us a call, my number is 866-842-5202. Remember that Business SOS, short here, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You could ask for your local bookstores as well. Remember to follow us in Apple Podcasts, Spotify, wherever you enjoy your shows. Until next week, this is Rich Sierra wishing you a happy New Year again with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.